Imagine a country with a digital population that just, completely dwarfs the entire population of Europe. We are talking about over 800 million active internet users.
Yeah, it's a massive, constantly shifting ocean of humanity. People scrolling, banking, buying, and sharing data every single second of the day.
Right. And now imagine the government of that country suddenly flips a switch and fundamentally changes the rules of the game for how all of that data is handled.
I mean, it's not just a rule change, it's a seismic shift. When a market of that sheer magnitude changes its regulatory framework, the ripple effects don't just stop at the border. They go global immediately.
And that is exactly what we are unpacking today. Welcome back to the deep dive into the source material. This is a very special edition because we are officially branding this the WeCyberYou Unlocked podcast.
That is pronounced WeCyberYou. And honestly, it is a very fitting name for today's topic because this legislation really centers on that relationship, the you in the digital equation.
Spot on. Cybersecurity and data privacy aren't just about servers and firewalls anymore. They are about the actual person behind the screen. And our mission today is to decode a massive, transformative piece of legislation.
The Indian Digital Personal Data Protection Act of 2023.
Right, which you'll often hear us refer to as the DPDP Act.
Which is thankfully a lot easier to say than the full title 3 times fast.
Much easier. Now, I've spent some time with the source material we're covering, and I have to admit, usually when I dive into legal texts or government acts, I brace myself for a really dry read.
Oh yeah, usually it's incredibly dense.
Exactly. But this one feels different. It feels incredibly consequential, not just for corporate lawyers, but for, well, you. For everyone.
It's consequential because it is deeply personal. It's
Yeah.
right there in the name. This is not just bureaucratic red tape or some obscure tax code. This is India's first comprehensive cross-sectoral framework specifically for digital personal data.
Replacing a whole patchwork of older rules that were, frankly, really struggling to keep up with the modern internet.
Yeah, the old rules just weren't built for the cloud era.
So here's our roadmap for the deep dive. We are going to break this down into digestible pieces. First, we'll look at the scope. Who actually has to follow these rules?
Then we'll look at the obligations. What companies literally have to do day to day.
Right. And then we'll cover the rights it gives to regular people, and finally, the penalties, which, spoiler alert, are absolutely massive.
Huge. And we should probably start with the who and the what. Because I think a lot of people might assume, oh, it's an Indian law. I'm sitting in London or New York, so this is just background noise for me.
That's a really common misconception. If I'm a developer in Silicon Valley or a small business owner in Berlin, why is the DPDP Act on my radar?
Because the internet doesn't have borders, and neither does the jurisdiction of this act, at least in a practical sense. The law applies to the processing of digital personal data within India, obviously.
But it has a longer reach.
Exactly. This is the key takeaway for our international listeners. It has extraterritorial reach. It applies to any entity, anywhere in the world, if they are processing digital personal data in connection with offering goods or services to people within India.
Okay, so if you target the market, you play by their rules.
Spot on.
Now, the sources use some very specific vocabulary that I think sets the tone for the whole document. Instead of calling you a user or a data subject, the Indian law uses the term data principal.
I love that shift. Data subject always feels a bit clinical. Data principal puts you at the center. The idea is that you are the principal owner of your information.
And the company collecting the data, they are called the data fiduciary.
Which is a fascinating choice of words.
It really is. Fiduciary is a term we usually hear in finance. Like your financial advisor is a fiduciary. They have a strict legal obligation to act in your best interest.
Exactly. By using that specific word, the law is signaling a shift in the power dynamic. It implies a relationship of trust. The company doesn't own your data. They are just holding it in trust for you.
They have a duty of care.
Yes. It frames the whole interaction differently than just, hey, I collected this data, so it's mine to sell.
That is a powerful mental shift. So if I'm a startup in Austin, Texas, and I launch a fitness app that suddenly goes viral in Mumbai, I am a data fiduciary under Indian law.
Correct. You are offering a service to those data principals, so you are on the hook.
Okay, so we know who is involved. Let's talk about what is being protected. The Act covers digital personal data, but the sources made a really interesting distinction about offline data that we need to clarify.
It sounds a bit tricky at first, but it is actually quite logical. The Act obviously covers data that is collected in digital form, anything you type into a website or an app,
Mhm.
but it also covers non-digital data if it is subsequently digitized.
So let's use a classic example to ground this. I walk into a bank branch, I sit down, and I fill out a paper application form for a credit card. Pen and paper.
At that moment, it's just paper. It was
Yeah.
not covered yet. But the second the bank clerk scans that document or types your name and address into their computer system, boom, it is now digital personal data, and the DPDP Act protections snap right into place. It bridges that gap between the physical and digital worlds.
That makes a lot of sense. Now, there is a nuance in the definition of personal data here that I think is really important to highlight, especially compared to other global laws.
You're thinking of the sensitive data categorization.
Right. In frameworks like the GDPR in Europe, there is often a strict separate category for sensitive personal data, things like health records, biometrics, your sexual orientation, and that data gets much higher protection.
Yes, that is standard in a lot of privacy laws. The DPDP Act, however, takes a completely different approach. It broadly defines personal data as any data about an individual who is identifiable by that data. But it does not create a separate heightened tier for sensitive data in the main text.
That seems like a double-edged sword. On one hand, it simplifies things, data is data, but on the other hand, doesn't that mean my email address is treated with the exact same legal weight as my medical history?
In terms of the core obligations, yes. It treats the data universe as relatively flat. The expert analysis we're looking at suggests this simplifies compliance for businesses. They don't have to maintain these massive, complex classification matrices for every single byte of data.
But I imagine critics have a field day with that.
They do. Critics argue it might leave highly sensitive information a bit more exposed than it would be under a tiered system. It is definitely a bold move to put it all under one big umbrella.
It certainly streamlines the conversation, even if it raises some eyebrows. Speaking of streamlining, let's move to part 2 of our deep dive. The obligations. If I am a data fiduciary, a company, I can't just hoard data anymore, can I?
The days of the vacuum cleaner approach to data, where you just suck up everything just in case you need it later, those days are effectively over. The Act is built on a few non-negotiable pillars. The first, and arguably the most important, is consent.
But we aren't just talking about any consent. We've all mindlessly clicked, I agree on a 50-page terms of service document we didn't read.
That does not fly here. The Act requires consent to be free, specific, informed, unconditional, and unambiguous. And it has to be managed through a clear notice.
Notice is the operative word there.
Yes. Before you collect the data, you have to tell the user what you are collecting and exactly why. And crucially, the user has the right to withdraw that consent at any time, just as easily as they gave it.
Which leads right into the concepts of purpose limitation and data minimization. These terms sound a bit dry, but they affect our daily lives constantly.
They absolutely do. Let's take the flashlight app example. It is a classic for a reason. You download a free app to use your phone's LED as a flashlight.
And the app immediately asks for access to your contacts, your GPS location, and your microphone.
Under the DPDP Act, that is a blatant violation of purpose limitation. You ask for data to turn on a light. You do not need the user's contact list to turn on a light. The purpose doesn't match the collection.
And data minimization means you shouldn't even be asking for it in the first place.
Exactly. You should only collect what is strictly necessary for the stated purpose. It forces developers to be disciplined. You can't just grab location data because you might want to sell it to an ad network next year.
This sounds amazing for the average user, but what about the really big players? The social media giants, the massive search engines? The sources mention a special category just for them.
Yes, they're called significant data fiduciaries, or SDFs.
Who decides who gets to be an SDF? Is it based purely on user count?
Not purely. The government decides. They look at factors like the sheer volume of data processed, obviously, but also the risk to the rights of the data principle, potential impact on the sovereignty and integrity of India, and even the risk to electoral democracy.
Wow, electoral democracy. That shows they are thinking about misinformation and social media influence.
Definitely. If you fall into that high-risk bucket, you get tagged as an SDF. And being an SDF comes with a mountain of extra homework.
What kind of homework?
Well, you have to appoint a data protection officer, a DPO, who is physically based in India. You have to appoint an independent data auditor, and you have to conduct periodic data protection impact assessments, or DPIAs.
For those who aren't deep in the compliance industry, what exactly is a DPIA?
Think of it like a structural engineering survey before you open a new bridge to traffic.
Mm-hmm.
Before you roll out a new feature or an algorithm that involves high-risk data, you have to formally assess what could go wrong. How could this harm the user? and what mitigations are we putting in place. You have to show your work.
So it forces companies to be proactive rather than reactive.
That is the goal. But even with all that planning, things can still go wrong. Data breaches happen, and this is where the Act gets very strict about security and breach notification.
This part of the source material actually made me wince a little on behalf of the corporate world.
It should. The Act mandates that companies implement reasonable security safeguards. That is the baseline. But if a breach occurs, if your data leaks, the fiduciary must notify two entities, the Data Protection Board of India and the affected data principals.
You have to tell the government and you have to tell the users. You can't just patch the vulnerability and try to fix it quietly in the background.
No sweeping it under the rug. This aligns perfectly with the context of rising cybercrime globally that the sources brought up. Transparency is the only way to mitigate harm. If my credit card info is stolen, I need to know today so I can freeze my card. If a company hides that from me just to save face, they are actively causing me further harm. The DPDP Act makes that hiding illegal.
It fundamentally changes the risk calculus. Security isn't just an IT department problem anymore. It is a compliance issue that goes right to the boardroom.
Absolutely. Now, we have talked a lot about what companies must do. Let's flip the coin. What can we do? Let's talk about the rights of the data principal.
This is the power to the people section of the deep dive.
It really is a robust toolkit. You have the right to access. You can ask a company, hey, what data do you have on me? And who exactly have you shared it with?
Which is often an incredibly enlightening exercise. I've done this with a few major tech services, and the sheer volume of behavioral data they hold is staggering.
It is terrifying sometimes. You also have the right to correction and erasure. If the data is wrong, maybe they have your address listed incorrectly and it's affecting your credit, you can force them to fix it. Or, if you are done with the service, you can tell them to delete your data entirely.
Provided they don't have a legal reason to keep it, right? Like tax retention laws.
Right. There are always exceptions for legal and financial compliance. But generally, the right to be forgotten is present. You also have the right to grievance redressal. Companies must have a mechanism for you to complain. You don't have to go straight to a lawyer. They have to provide a dedicated channel to hear your issues.
But there was one right in the source material that really stood out to me. It felt surprisingly human for a legal text, the right to nominate.
This is arguably one of the most forward-thinking parts of the Act.
Yeah.
It directly addresses the concept of digital legacy. Digital legacy. That is a heavy concept.
It is, but it's totally necessary. Think about it. We live our entire lives online now. Our photos, our personal emails, our documents, our memories, they are all stored in the cloud. What happens to all of that when we die?
Usually it enters this awful legal gray area. I've read horror stories of parents trying to access a deceased child's social media just to get the photos, and the massive tech company just saying, sorry, privacy policy says we can't give you the password.
Exactly. It creates a traumatic bureaucratic wall for grieving families.
Yeah.
The DPDP Act solves this. It allows a data principal to formally nominate another individual who can exercise their rights in the event of death or incapacity.
It is basically a digital will.
It is. It acknowledges that digital assets are personal property. Just like you decide who gets your car or your house, you should decide who manages your digital footprint. It treats the user as a human being with a life cycle, not just an active account ID. That is a huge aha moment for me. It really centers that human element we talked about at the start of the show.
It does. And if we zoom out, these rights reflect a broader philosophy called privacy by design. But there is a real tension here. The expert commentary points out that while these rights are exceptionally strong, India is also trying to grow a massive digital economy. They don't want to strangle innovation.
Right. If you lock the data down so tightly that nobody can use it, you kill the AI startups. You kill the fintech innovation before it even starts.
That is the delicate balance. The law tries to walk that line carefully. It says you can process data, you can build cool, innovative things, but you have to do it with extreme transparency and respect for the user. It is not banning the game. It is just clarifying the rules.
Okay, so we have the rules, but rules are just polite suggestions unless there is a severe consequence for breaking them. And from what I am reading, the DPDP Act has some very, very sharp teeth.
Teeth is putting it mildly. The financial penalties are immense.
We are talking about fines up to 250 crore rupees.
Which is roughly 30 million US dollars.
Now, for a trillion-dollar company like Google or Meta, 30 million might sound like a rounding error, but we need to look closer at the actual phrasing in the Act.
You're right to point that out. The penalty is up to 250 crore per violation. It is not a one-time speeding ticket. Mhm. If a company has systemic failures, say they fail to prevent a major breach, and then they fail to notify the board, and they also fail to protect children's data, those fines can stack up rapidly.
And suddenly you aren't talking about pocket change, you are talking about a significant existential hit to the bottom line.
And importantly, these penalties apply to specific preventable failures. For example, the failure to take reasonable security safeguards to prevent a breach is what triggers that maximum penalty. Failure to notify the board of a breach can trigger a fine of up to 200 crore.
So if a company gets lazy with their security architecture or they try to cover up a hack, they are risking hundreds of millions of dollars.
It forces the issue entirely. It makes data privacy a board-level, CEO-level discussion because the financial risk is just way too high to ignore.
Now, I want to touch on one final major piece of the puzzle from the sources, the border. We talked about foreign companies coming into India, but what about Indian data going out? Cross-border data transfers.
This is always the most hotly debated part of data sovereignty. Governments worry that if data leaves their geographic borders, they lose legal control over it.
Some countries use a strict data localization model, right? Where they say data must stay on physical servers located within our country.
Right. Or they use a whitelist approach, where they say you can only send data to these 5 specific countries that we have pre-approved and trust. The DPDP Act actually takes a different approach. It uses a blacklist mechanism.
How does that work in practice?
Essentially, the law says you can transfer personal data to any country in the world unless the Indian government specifically restricts transfers to that particular country.
That feels remarkably open.
It is incredibly business-friendly. It creates a default state of flow. For a tech support company in Bangalore serving clients in Europe, or a fintech startup using cloud servers hosted in the US, this is huge. They don't need to beg for government permission for every single data transfer. They just need to check the no-go list.
So unless the government explicitly says do not send data to country X, maybe for national security reasons, the data is free to move.
Yes, it aligns India with global digital standards while keeping a crucial safety valve for strategic concerns. It is a very pragmatic way to handle the reality of the modern cloud, where data is constantly zipping around the planet anyway.
It seems like the entire act is trying to thread that exact needle, being unyieldingly strict on user protection, but remaining flexible on global business operations.
That is the constant tension of modern governance. How do you protect the citizen without accidentally strangling the economy? The DPDP Act is India's answer to that question. It creates a framework of trust, because if users trust that their data is genuinely safe, they will use digital services more. If they use services more, the digital economy grows.
Trust as an economic engine. I really like that framing. So let's bring it all home. If you had to distill this entire deep dive for our listener who is maybe feeling a bit overwhelmed by all the legalese we just covered, what is the ultimate takeaway?
The takeaway is this. The DPDP Act is a modern, comprehensive law that secures India's massive digital ecosystem. It establishes exceptionally clear rights for you, the user, including the vital right to digital legacy. It imposes strict consent-based obligations on companies, backed by fines up to $30 million per violation. And it adopts a flexible, blacklist-based approach to global data transfers to keep the economy moving.
It really is a complete package. And whether you are a developer writing code, a CEO setting corporate strategy, or just someone scrolling through social media on your commute, this framework is going to actively shape your digital experience.
It sets a massive global standard. India is a major player. When they decide this is how we do privacy, software giants worldwide have to adapt their global products to match.
Well, here is a final provocative thought I want to leave you with, something for you to mull over after we sign off. We talked a lot about that blacklist approach to data transfers, the idea that data can flow freely across borders unless it is specifically stopped by the government.
Right, the default state of flow.
As India's digital economy continues to explode, and it is growing incredibly fast, will this open-by-default approach become the new global norm? Will we see other heavily regulated countries moving away from strict data localization and adopting this model? Or, on the flip side, will that lack of a specific sensitive data category that we discussed earlier cause massive unforeseen issues down the road when highly personal data inevitably leaks?
That really is the million-dollar question. When you treat all data equally, you absolutely simplify compliance, but you might miss the crucial nuances of high-risk information. It is a bold regulatory experiment, and the rest of the world is watching very closely to see how it plays out.
Indeed. We will certainly be keeping a close eye on it, too.
Absolutely.
That brings us to the end of our deep dive into the source material. We hope you feel a little smarter, a little more informed, and maybe a little more empowered about your digital rights.
Because knowledge really is the best firewall.
I love that. Before you go, please make sure to follow the channel. We are the WeCyberYou Unlocked podcast, and we have so much more deep dive content coming your way.
And if you want to explore further or find more educational cybersecurity content exactly like this, please go visit WeCyberYou.com.
That is WeCyberYou.com. Go check it out. Thank you so much for joining us, and until next time, stay curious and stay secure.